legislations, many laws have been passed. But I would say that closing the gap between the laws on the book and their implementation is the most pressing concerns. As long as violence against women continues, we cannot claim to be making any real progress towards equality, development, and peace. I thank the organizers and also thank you all for a patient listening. Thank you.
Thank you very much, madam. Women faces violence in war and peace, and she has highlighted the violence, what it amounts to discrimination and violence of all forms, economically, socially, sexually, etc. And violence both physical and psychological. And she has also highlighted regarding the structural violences, denying employment, wages, education, etc. Then UN view on with regard to the violence against women. And finally, in the Indian scene, we have come to the trafficking, another violence against women, and the constitutional provisions and the Supreme Court stand on the violence against women. And extremely thankful to Dr. Ratna Navada, because I have requested her to complete within 15 minutes, hoping that it does not amount to a violence against her when I said you have to finish in 15 minutes. So positively she has finished. Now I am very much thankful to her for having presented this interesting paper. Now I request Dr. C.S. Patil, Principal, University Law College, Dharwad, to speak on social justice and human rights. Respected Chairman, Dr. Sebastian, Dr. David Ambrose, Dr. Ratna, learned delegates, distinguished guests, friends. I have taken the liberty of writing my paper on a different topic than that is announced. My paper is on human rights enforcement machinery. We have talked much about social justice, and I felt I will take you through the enforcement machinery that is provided for human rights. See, one more conference on human rights. There is an old slogan that it is the remedy that makes the rights effective. What is that we have done all these years, starting from the enactment of 1993? How many years elapsed? How long we will talk like this without providing effective remedies? Okay, there is a provision in the 1993 Act for the constitution of state human rights commissions, which will be more accessible to the ordinary public than the National Human Rights Commission. There is a provision for the constitution of state human rights courts. What has happened till now in India is to be taken stock of. In 2005, the Karnataka government, under the leadership of Sri H.K. Patil, the Department of Law and Parliamentary Affairs adopted a policy paper, policy and action plan for the ministry, wherein they made their commitment towards human rights very, very manifest. In June 2005, Karnataka notified the constitution of the State Human Rights Commission. And what was notified in 2005 became functional in 2007. And with that, Karnataka has joined the very select club of states with human rights commissions. But what this commission does, the powers are same as they are available to the National Human Rights Commission. So motu, any complaint, etc., they
conduct an inquiry. After inquiry, what happens? There was a very, very massive amendment to the Protection of Human Rights Act in 2006, wherein certain of the additional things were provided, additional powers were provided to the Human Rights Commission, both national and state. They conduct an inquiry, and if the inquiry discloses the violation of human rights by a public servant, there cannot be complaint of violation of human rights by a private individual. State commission or national commission will not look into violations of human rights by individuals. It should be by the public authorities, public servant. Either it should be violation of a right, or it should be a negligence in prevention of violation of a human right. In that situation, the commission will make appropriate recommendations. One, it may be a recommendation for payment of compensation, damages, either to the victim or to the dependents of the victim. Second, there may be a recommendation for initiation of prosecution or initiation of any other departmental action against the violator. Third, the commission may either approach the Supreme Court or the High Court for the appropriate writ. It may recommend to the government for the grant of interim relief. This has come after 2006 amendment, either to the victim or to the relatives. It has to provide a copy of the inquiry to the petitioner. Earlier that provision was not there. And the government or the authority to whom the recommendation is made has to act within 1 month. That is a time stipulated which brings in seriousness to the recommendations of the commission. And every year it has to publish all its recommendations along with the action taken by the appropriate government or the authority for the information of the public, which will make it very, very clear to the public as to which is that government which is so committed to the cause of human rights. Okay, when we look through the scheme of the things, the commission can only make recommendations, a series of recommendations. The track record of National Human Rights Commission is very, very good. Till now, there are certain instances wherein the initial reaction to the recommendations is in terms of seeking clarifications. And after clarifications coming forth, the person to whom the recommendations are addressed have fallen in line, they have followed the recommendations. Otherwise, they will be compelled to go to the court. Our Human Rights Commission, State Human Rights Commission, has to go for such recommendations which can be on par with the recommendations that are rendered till now by the National Human Rights Commission. Then only it can be very, very meaningful. But even then, that is a bottleneck. One commission at the state level, one commission at the national level, whether it can meet the requirements of enforcement of human rights of crores of people. That's why the parliamentarians, when they adopted the Act in 1993, they made a provision for Constitution of Human Rights Courts. The concerned section is Section 30, Human Rights Courts. But unfortunately, what has happened is, till today, except Karnataka state, no state worth its name has constituted human rights courts. We, people belonging to Karnataka, should be very, very proud of this fact, even though we have done it after more than 13, 14 years. Why? Why this country, which has enacted an act in 1993, has not put the enforcement machinery in place over a period of more than a decade? This is a problem of drafting. Director Dakshinamurthy was involved in the process. I was very much part of the process. H.K. Patil was part of the process. Former Law Secretary Sri Chamaya, Robinson D'Souza, Registrar National Law School, Justice Malimat, Justice Shivraj Patil. How many people broke their skull to navigate the Karnataka courts through this statute? It is all very, very tricky and slippery. The language of Section 30. Section 30 empowers the state governments to constitute courts, human rights courts, for speedy trial of offences arising out of violation of human rights. At the district level, offences arising out of violation of human rights. This is the bottleneck. What are these offences that arise out of violation of human rights? There is no definition in the Act. For which offences the courts are to be constituted? Which are these offences which involve violation of human rights? The interpretation is very simple. There are two requirements. One, first and foremost, it should be an offence. The concerned public servant should have committed an offence. Second, it should involve violation of a human right. These are the offences involving violation of human rights. If he has committed an offence which involves no violation of human rights, then it will go before the regular court. It will not go before the human rights court. Otherwise, it will, only when it involves human right, it will go before the human rights court. And this should have been made very, very clear in Section 30 of the Act. But because that clarity is not there in Section 30, no state probably took initiative to enact the, to constitute the human rights courts. That's why the National Human Rights Commission has suggested certain of the amendments to Section 30. The existing Section 30, changed the Section 30, reasons for the change, third column. They have written very beautifully. The noble object of providing for the constitution of human rights courts is defeated by this clumsy drafting. This is to be more clarified so that human rights courts may come into existence. Unfortunately, this amendment that was suggested by NHRC was not carried out in 2006 when other provisions were amended. So, except Karnataka, in any other places, these highly accessible courts at the district level are not available for the enforcement of human rights. Second bottleneck, Dakshinamurthy will not agree to this interpretation. Section 41, which delegates power to the states. Power is delegated to make rules for the purpose of implementing this act. General clause. Without prejudice to the foregoing, the rules may provide for salary, leave, vacation, driver, this. Whether this is adequate delegation of power to lay down rules for the governing of the human rights courts. We debated, we were confused, we consulted, and ultimately took a decision. I was asked by the then law minister, Professor, what is your earnest opinion about this? Then I said, sir, let us see what happens. Champakam Dorai Rajan, I said, this is the first LLB case we study. Some government makes some bold order. What happened? Crashed, fine, law changes. Supposing the order, communal government order was upheld then only, then also cause would have been vindicated. They struck it down, then again the cause was vindicated. I said, sir, we will proceed, we will notify these rules. Let any High Court or the Supreme Court quash it. If they quash, the message will go to the nation that the law used to be amended. If they uphold, we are victorious. Take a chance. All of us together decided to take a chance, and the rules were notified. Notified in January 2006. We have titled these rules Karnataka State Human Rights Courts Rules. This is the problem. January 2006, these things have come into existence. Quite a few of us are not aware of these rules. Because the rules are affectionate to us, wherever I go, I have made it a policy to take a copy. It is just 2-page gazette notification. Take a copy, go and distribute. We did it in Shumaga. Jagdish helped me in doing that. This time I made a different idea. I made Dr. Ravindra to circulate it on my behalf. To my paper I have annexed it. The Karnataka rules are annexed to the paper which is bound in the compilation that is provided by the organizers. You can leisurely go through those rules because these are the rules of relevance. If any person comes to you and asks a question, sir, I feel my human rights are violated, where I will go, what I can do, then you pick up those 2 pages and advise him, look, go to the principal district court, or wherever principal district court is not there, the regular district court for the purpose of. So, what are these rules? Where the complaint is to be filed? Complaint, because it is against a public servant, the complaint is to be filed with the human rights courts. The complaint is not going to police station. The complaint is going to the court. Who can file a complaint? The victim can file a complaint. His legal representatives can file a complaint. A registered non-governmental organization can file a complaint. A public-spirited individual can file a complaint. But when it is an NGO or a public-spirited individual, you should take the consent of the victim on an affidavit. It should be a sworn consent. Then only he is getting the locus standi to file the complaint. This is in order to prevent the abuse of this complaint provision. Third, against whom? It is to be against a public servant who has committed violation of a human right, who has abetted commission of violation of human right while acting under the color of his office, while acting officially, not in private capacity. What is the procedure after the complaint? Court may conduct its own inquiry. Alternatively, it may order an inquiry by an officer not below the rank of Superintendent of Police, who has to submit his report within 15 days. He has to conduct his inquiry and submit the report within 15 days. If it is not possible for him to complete the inquiry in 15 days, what he has to do is he has to go to the court with his diaries, report, and take extension, and within that extended time period he has to complete his inquiry and submit the report. If the police reports that no offence is committed, what we call as B form or something like that, if the police says no offence is committed, maybe there is a sort of protectionism. That's how a private individual will look at. This fellow is also a government officer and he shielded another government officer. In that situation, what happens is the court will send a notice to the complainant with a copy of the investigation report. Look, this is what police people have to say about your complaint. Do you have any evidence to proceed? Shall we proceed? Come out with that evidence. If there is a prima facie case, then the court will decide to proceed. Otherwise, the matter comes to an end there itself. Then what happens? When there is sufficient evidence on record, then the problem of sanction for prosecution will come. Court will forward the complaint with all the material to the competent authority for obtaining sanction for prosecution of that concerned officer, and this competent authority to whom the application is forwarded has to respond within 30 days. Okay? Then the trial will proceed according to the provisions of Criminal Procedure Code, and the trial is to be conducted day by day. The case cannot be adjourned for more than a day. If it is to be adjourned for more than a day, it is to be done for adequate and special reasons which are to be recorded. So it cannot be just posted to the next longer date so easily. Then the trial before the Human Rights Court will have precedence over trial in any other, because these people who violate human rights are the most wanted people. They will be wanted in different courts at the same time. If that is a wanted person, then on priority he is to be brought before the Human Rights Court, and he should not be sent to, he has to stand the trial for those offences subsequent to standing trial at the Human Rights Court. This is the process that is provided. We made the law very stringent. We liberalized it. We have cast, recast, molded, so many things. How effective these rules are, we have to wait and see, because we are notified only in 2006. January 2007, January 2008, we are entering the third year. We are at the end of completion of 2 years. And 2 years is probably not adequate time for us to come to know the existence of these rules and codes. We have to canvass these things. All of us who speak of human rights have to speak of human rights codes also, because whatever human rights jurisprudence that we speak, without speaking, enforcement machinery should remain incomplete. So without assessing the relevance, effectiveness of the rules, I dare suggesting certain of the changes to the rules. Amendments. 1. As per the rules, complaint can be filed by a public-spirited individual or an NGO with the consent of the victim. If the victim is no more, then there should be a provision to file a complaint with the consent of the relatives of the victim. That is one suggestion I have made. Second, whenever the application is forwarded to the competent authority to give sanction for the prosecution of the concerned officer against whom there is an allegation of violation of human rights, the authority has to give sanction in 30 days. If the authority keeps quiet, it will not respond for 30 days, then what we should think? Whether we should take it to be a consent, there should be a provision, there should be a deemed provision, there should be a provision for presumption of consent if they have not responded at the end of 30 days. Third, if the sanction is rejected, this we tried in the initial draft and later we dropped it, if any authority refuses the sanction and the court feels that it is a fit case, there is prima facie evidence, there should be power available with the court to send back the file for reconsideration of the decision by the competent authority once again. And fourth, human rights courts should be vested with express power to award compensation to the victims. Because for compensation we cannot expect already aggrieved person to fight another long civil legal battle. And fifth, there is no express provision providing for appeal. Appeal is available even otherwise. For the information of the general public, it may be good to expressly mention in the rules that from the decision of the Human Rights Court, there lies an appeal to the concerned High Court. That's all that I wanted to present. Thank you very much for the patient hearing. I thank the organizers for providing this opportunity. Thank you.
Dr. Patil, thank you very much for presenting the issue of human right enforcement mechanism or the machinery briefly but clearly as from the 93 Act onwards and the constitution of the Human Rights Commission at central and the state level and the compensation to the victims, recommendations that can be given to the government, the constitution formation of the human rights courts, and also highlighted the need for the High Court, the Human Rights Court shall have the power to award the compensation, and instead of recommending to the government for awarding of compensation. So briefly but clearly he has brought out the existing Human Rights Act and its shortcomings and the lack of implementation of the Act in various parts of the country as at the state as well as at the central level. Thank you very much, Dr. Patil. Now the last speaker of the day in this session is Dr. David Ambrose, Department of Legal Studies, University of Madras, Chennai. He will be speaking on human right is physically challenged. Here is your stage, sir.
Ever smiling and humble chairman and my beloved friend, Dr. Sebastian, first speaker of the last session, Dr. Ratnagar, and my dear friend, the second speaker, Dr. Patil, and distinguished resource persons and the delegates, my dear students. I'm very happy. This is one of the success